is that it will burden the client's liability, as it will involve a contract between the client and another party, as we can illustrate by this case, whereby in this particular case, there are a few parties to this case, which are the applicant, the petitioner, and the respondent. So basically, in this case, there was a petitioner which had filed a petition to wind up the respondents, which is a company, and there are a few contributories party, namely the applicants themselves, which opposed to this petition. But basically, the agreement between them, or a consent order that was established, was that the petitioner would withdraw the winding up petition, subjected that the respondent and the applicants would buy some asset from the petitioner with a specific kind of payment lah. So basically, this case was decided on 2004, and the consent order was made but not yet enforced. And in this case, the petitioner had agreed to withdraw the petition, and when they were about to perform their obligation, the applicants wanted to oppose the consent order, because they did not want to buy the assets manufactured or provided by the petitioner embedded under the consent order. So what the applicants did was, they had invoked the ground that their solicitors, who had represented both the petitioner and the respondent, including the applicant, because the applicant is the contributing parties towards the respondent. The applicant, they had submitted to the court that the solicitor that represented all of them had acted without authority, and they applied to the court to set aside the consent order, as it was entered without their authority. So the issue in this case was straightforward, whether the solicitor's action in entering into such consent order while in representing the applicants were without authority. And the second issue is whether the court has jurisdiction to allow such consent order. So basically, the first issue in this case is in regards to our topic today lah. So when we talk about this case, actually a negotiation had been made by all the parties in agreeing to the terms of the consent order, whereby it had taken up to 3 days. So that's the main point or main gist that the court had taken a look in deciding whether the solicitors that had represented them in the case had actually entered into such consent order with applicant's authority or not. So in this case, High Court of Kuala Lumpur had dismissed the application, which was the application to set aside the consent order, based on few grounds. Number one, there were insufficient evidence that portrays such solicitor had acted without authority. As in this case, the applicant did not submit sufficient evidence or enough evidence to show that such solicitor had acted without their authority. And number two is that the court said that impliedly the solicitors had authority from applicant, because in this case the court had strengthened the fact that express authority is not needed to be proved unless it was asked during material time. In other words, when a lawyer or solicitor is asked in regards upon their authority to represent someone in engaging into an agreement or other contracts, only then it is pertinent to prove such express authority, or the parties may impliedly acknowledge that such authority had been given by their respected solicitor, by their respected client.
Can you repeat the last sentence again?
Pardon me, madam?
The last
The last
point, can you
sentence.
repeat?
Last point in these slides, or the last point that I just mentioned?
That you just said.
Okay, so basically, in this case, the court had stressed that an express authority is not needed to be proved unless it is asked by a party during material time. Means that if an authority is to be proved, an authority is needed to be proved only when it is asked during the crucial time. During the material time means that maybe during the negotiation takes place, or maybe during before the negotiation. As in this case, the negotiation between the parties, as mentioned in point number 3, had taken a period of 3 days. And during this time, the applicants or other parties had never asked in regards to the solicitor's authority whether such solicitor had been given authority into entering such consent order. Because this negotiation had taken a period of 3 days, the court indeed impliedly, the court held that impliedly for this impliedly that the solicitors had been given authority to agree or to enter into such consent order by the applicants themselves, as there were no other parties that raised such question during that material time. The material time here is during the negotiation to enter into such consent order. Okay, madam, does that answer your question?
What is the conclusion you can derive from this case with regards to the consequence?
Okay. So basically, the High Court had dismissed the application, right? So the conclusion that we can derive is that if we are taking into account on the perspective of a client, if such if such application is to be made, it would affect the respondent liability as a company. Why? Because as a company, if such consent order was to be made, was not to be made. I'm sorry, I need to straighten my sentence. If such consent order was invalid or not to be made, as the court will declare the solicitors had acted with the authority, respondent here as a company would be wind up, thus engaging them to suffer more liabilities, as the petition itself would not be withdrawn. And one more thing is that the court stress in this case is that this kind of ground actually can open a way for people to avoid from performing their own obligation. Because in this case, the after the negotiation had taken a period of 3 days, only then the applicants did not want to perform their obligation, which was to buy the assets provided by the petitioner. This shows that they want to use this reason or ground to escape from performing their obligations under the consent order. Okay, madam?
Okay, what happened to the, what about the relationship between the counsel and the client? What is the consequence?
The consequences of the counsel and the client's relationship.
Yeah, how does it affect the, the legal relationship between the counsel and the client?
Okay, the consequence that we can derive in terms of relationship, I think it will affect the relationship badly, as the client the lawyer's reputation will be what we call would be jeopardized, as if he had not been given authority to act upon the clients, which were the respondent, the petitioner, and the applicants themselves.
Okay, in this case, was the compromise considered to be, was compromise ataupun the consent judgment was set aside ataupun wasn't, ataupun it stood?
The consent judgment was set aside, madam, by no, the consent judgment remain to be enforced, because the application to set aside the consent judgment was denied, was dismissed by the High Court of Kuala Lumpur.
Okay. The reason being?
The reason being is that this one. Okay. There was no sufficient evidence, means that the applicants could not show the court why does such solicitor had acted without authority, because they didn't raise any material question during the 3 days negotiation in regards to the solicitor's authority, like why they should ask that did that solicitor had entered with our consent as a contributing parties to the respondent during the 3 days negotiation, but they did not ask. They only managed to oppose the petition after the consent order was made, but yet to be enforced.
Okay, I would like to ask someone in your group, TLB1, right?
TLB2, madam.
TLB2, yeah.
Yes.
With regards to this kind of situation, yeah, that a consent order may have been entered into, and prior to that, there was a compromise achieved. Okay. In your case, 3 days have passed. Never did the client raise anything during the negotiation. Yeah.
Yes.
If I were to actually create a hypothetical question using this kind of facts, what is the ground on which you can say that the client can no longer challenge the compromise or apply to set aside the consent order? There is this key, have to use this key word ataupun this particular term, which I think would be would fit with the situation that we are discussing now. Ada siapa-siapa nak jumpa? Apa terma yang kita boleh gunakan untuk menunjukkan yang klien tidak objek dan boleh dianggap menerima kompromis tersebut? You are deemed to have accepted when you do not actually, or you have failed to challenge or to resist atau object to the compromise. Mungkin Zarif Aiman ada? Zarif Aiman ni wujud ke tak wujud ni dalam grup ni? Ada?
Rasa macam tak ada, madam. Tak
Abdul
adalah, madam.
Abdul Had. Abdul Had ada?
Ada, madam. Hello.
Ya, you faham tak soalan saya?
Can you refresh the question, please, madam?
Okay. Dalam keadaan di mana, in a situation where a compromise has been achieved between the parties, alright, and the client letter wishes to challenge the compromise, okay, the lawyer on behalf of the client can put up an argument saying that the client cannot challenge it if he has failed to sufficiently showed his opposition or disagreement or objection to the compromise that has been achieved. Okay, just like the situation in this particular case your colleague has just presented. Okay, it shows that within the 3 days of negotiation, the client did not actually imply or do anything to challenge the whatever conduct of the of his counsel. Betul tak, Wafi?
Yes, madam.
Okay, apa ground yang boleh kita guna? Ini penting untuk you faham. Kalau saya gunakan fakta dalam kes ni, I would like you to raise this particular issue of apa? Siapa boleh bantu?
Madam,
Yeah.
can I use implied authority, which
Okay, right authority ataupun apa?
acquiescence?
Acquiescence or ratification. Betul?
Yes.
You ratify by being quiet. You ratify by not raising an issue with your counsel. Jadi bila you nak challenge later on, you have to show that you have actually opposed, okay, objected or prevented your client from doing a particular conduct amounting to a compromise settlement. Ya. Jadi the keyword here that you must use untuk attract marks yang bagus adalah ratification, acquiescence, apa result dia. Okay. Alright, terima kasih. Ada lagi, siapa lagi yang nak present? Consequences of acting without authority.
Madam, ada lagi 2 case actually.
Boleh cepat sikit tak? Kita nak pergi kepada TLB 1 pula
Boleh. Yan, dengan Imran dengan Atirah akan sambung.
Teruskan baca, please make sure you highlight consequence dia tu apa you nak cakap. Baru you cerita pasal case ni. Kalau tidak kita jadi lost. Macam you suruh kita imply daripada case ni consequence dia apa?
Okay, madam. Can you hear me?
Yeah.
Okay. My name is Nur Atira binti Arinan. I am going to present the second case regarding the consequences of solicitors who act without authority. So basically, this case is the case of G. Balan anak lelaki Govindasamy. But before that, Wafi, can you share this slide for the case? Okay, so this case is G. Balan anak lelaki Govindasamy and Lee Moy Moy and others, which the case is actually related to the warranty of authority, which in this case, the case started at the trial court in which the plaintiff had purchased a piece of land, which the plaintiff in this case, which the Lee Moy Moy, had purchased a piece of land from the purported owner, but it was found later that the purported owner was not the true owner of the land, and that he was a fraudster who impersonated the true owner. And then the plaintiff then filed an action against Jibalan anak lelaki Govindasamy, which is the solicitors who were acting for the purported owner for damages for breach of warranty of authority to act. And then the case was brought at the trial stage. The trial judge held that the Jibalan was liable as he had an implied undertaking that he had the authority to act for the purported owner as the true owner of the land. But the case was brought to the appeal, and the issues for determination is whether the warranty of authority given by the defendant was more extensive or comprehensive in effect, so as to warrant that he was acting for the true owner of the land. And then we proceed to the principle that was brought by the trial judge at the trial stage, which is the principle in the case of Penn and Bristol and West Building Society and others, where in the case, the judge had highlighted that where a person by word or conduct represent that he had the authority to act on behalf of another, and then and that representation had induced a third party to act in a manner in which he would not have acted if such representation had not been made. So the person, in this case, the court highlighted that where a person who made the representation is liable for any loss caused by the third party at breach of implied warranty. And then
boleh speed up tak sebab kita ada limited time. Kita pun nak go to another session. I have another session kejap lagi. Boleh summarize saja.
Okay, that's it. So in this case, I just proceed to the consequence. Okay, madam?
Yeah.
Okay. So in this case, actually warranty of authority is actually related to the agent and principal relationship under the Contract Act 1950. So in the contract, basically, the general rule is that under Section 183 of the Contract Act is that where an agent had contracted as an agent, the agent cannot be made personally liable to the third party who contracted with him. Thus, in this case, the defendant is not liable for breach of warranty of authority because he cannot be, as under the law of agent and principal, the general is that an agent cannot be made personally liable to the third party who is contracted with him. So the consequence of the solicitors who act without authority in this case is that actually it was brought by the defendant is that he was okay, wait a second. Is actually if there is a breach of warranty of authority, he is made liable if his act is induced by his act as an agent, and he also liable for the loss of the third party who induced by his warranty of authority. Okay, that's all.
Okay, in this case, the counsel was not liable on the basis of principle of
warranty of authority to act.
Warranty of?
Warranty of authority.
Okay, so in this case, he was in other words,
Yes.
the breach of authority did not implicate him as a counsel.
Yes, but he was actually he's not breach for warranty of authority, but he is liable for breach of stakeholders' duties, which is the another part of this case.
Okay, what about what if I ask you about the implication? Let's say you have conducted your duty and it was challenged by your client, saying that you were not authorized to do so and so, okay, as a result of which, okay, your client had to pay an amount of money to maybe to the defendant if your client is the plaintiff, all right?
Okay.
But if it is proved that you acted without the authority, so what is the implication on your client? Can he, be exempted from paying the other party because of what you have done?
Okay.
Can
Basically.
anybody from your group, TLB 1,
TLB2, madam.
sorry, TLB 2, Nurul Hasanah, ada tak? Faham tak soalan saya, Nurul Hasanah?
Madam, can you repeat the question, please?
Okay. Is your client bound, okay, by the act of you as his or her solicitor if you have acted without the authority? For instance, okay, as a result of your conduct that has exceeded the authority or was done without the authority of your client is required to pay the defendant. Kalau dia plaintiff, dia kena bayar defendant, for instance, a certain amount, okay, as a judgment, okay. Whereas this is not something that it is not his fault lah, yeah? He did not actually authorize a lawyer to do a certain maybe he did not authorize the particular conduct, okay, but because of that he had to pay the other party a certain amount as a liability. So dalam keadaan tersebut, is the client bound by the act of his solicitor?
Forgive me if I'm mistaken, but I think yes, the solicitor is bound by that because solicitor has to exercise their duties towards the client.
It was held that it was if it was proved that the counsel exceeded ataupun did not act, it was proved dibuktikan.
So it was the solicitors that is wrong in here.
So there is actually a practice at common law whereby the client, being the plaintiff in the case that I'm discussing now, okay, can apply for an order from the court. Okay, can apply to move the court for an order that the solicitor concerned pay the cost of the plaintiff, okay, including the cost which he had become liable to pay to the defendant, as well as the cost of the defendant. So ni dalam case dalam case Reynolds and Howard, the English case, yang mana you boleh apply kepada mahkamah untuk satu perintah, okay, supaya kos tersebut dibayar semula oleh counsel yang telah bertindak di luar daripada authority atau melebihi limit authority tersebut. Faham tak? Are you with me? This is one of the consequences lah yang you boleh discuss. Okay, you boleh tengok contohnya case ni old case English case, Reynolds and Howell, Reynolds versus Howell, Howell, 1873 LR page 8.
Madam,
Yes.
correct me if I'm wrong. As for the general rule under this subtopic, the general rule is that the client must compromise with the counsel, right? But as for the exception where error was made by the counsel, so the client can turn the blame on the counsel. Is that right?
Dia depending on the conduct of both parties. Macam tadi in the first case, Wafi discuss yang tu seolah-olah ada bentuk acquiescence ataupun ratification. Okay, dia tidak challenge, dia tidak ada apparent act to challenge the authority or the conduct of the solicitor during the negotiation, kemudian dia dihalang lah daripada menidakkan atau object later on. Alright. Salah satu lagi adalah kalau dia in the ordinary course of your duty to negotiate and achieve a compromise, okay, tidak ada masalah. Kecuali apabila boleh dibuktikan memang tidak boleh, okay, klien tidak bersetuju, ada express authority, express objection dalam keadaan tersebut, dan you have to prove lah sama ada memang betul ada express objection by the client ataupun telah ada ratification ataupun you were acting in the ordinary course of your duty as a solicitor untuk settle out of court. Okay. The general rule is that unless expressly instructed, okay, a solicitor has no authority. But in certain ordinary, okay, conduct of in the ordinary course of conduct, okay, you boleh bertindak, okay, on behalf of your client to achieve a compromise, except in the case of sale and purchase and contract, right? So the issue is you have to prove lah sama ada betul telah bertindak dengan authority ataupun tidak ada authority. Kalau tidak ada authority, ada implication pada klien, apa hak klien tu. Itu adalah salah satu perkara yang you should also discuss. Okay. So in the Penn and Bristol, did I discuss this in the lecture ataupun tak?
No,
Case.
madam. I extracted this from the current case.
I think macam I came across this one, where a person by word or conduct represent that he has authority to act on behalf of another, and a third party is induced by such representation to act in a manner in which he would not have acted if that representation had not been made. The first mentioned person is the warrant is liable for any loss. Okay, ini adalah apabila berlakunya kerugian ke atas third party. Okay, third party. Dalam case you tadi, siapa third party?
The third party is the purchaser of the land.
So in this case, was he bound by the by the conduct of the solicitor, the third party?
The third. Sorry, madam. Can you repeat?
So what was the right of the third party based on this principle? What is the right?
Under this principle, under this principle, the third party, the solicitors is liable if there is a loss suffered by the third party, and then if there is a breach of that implied warranty.
Even if he had acted in good faith under a mistaken belief that he had such an authority. Okay. So yang ni berlaku tak dalam case tu? Dia memang ada good faith.
but yes, but there is that is not been proved. There is a good faith under a mistaken belief. Under
Right. So the implication can extend to third parties as well. Boleh baca balik case ni. Kalau berlaku pada third parties, you may want to quote the principle in this case. Alright. Even in the case where the other party can also challenge the authority of the plaintiff solicitor. Okay. A defendant can challenge the authority of the plaintiff solicitor to institute proceeding. Okay. By the solicitor to produce the authority on which he acts. Maksudnya di sini kalau defendant has doubt sama ada plaintiff solicitor tidak mempunyai authority untuk bertindak dalam sesuatu proceeding, the defendant solicitor can also challenge it. So he can challenge the retainer of the solicitor of the plaintiff by substantive motion. Kalau ada retainer lah, sometimes tak ada retainer ya. Okay. Court mempunyai kuasa untuk strike out the proceeding. Ini satu lagi implication ataupun consequence. Jikalau if the facts can be established to the effect that the counsel lacks capacity or authority to act. Okay. Boleh?
Yes, madam.
Tambahan saya bagi poin tambahan untuk you cari lagi kalaulah keluar dalam periksa ke apa tak terkeluar daripada rangka jawapan lah. Ini adalah antara implications and consequences lah. Okay, boleh cari juga sama ada retainer itu boleh dihentikan. Apa kesannya kepada retainer? Kalau ikutkan keadaan biasa, a retainer will subsist until the judgment is executed. Okay. Ataupun the business is completed lah on the stipulated term. But if the counsel has acted to the effect that he has breached the terms in the retainer, then what are then the right of the client? Boleh cari juga kesannya di situ ya. Okey, boleh kita teruskan. Ada lagi tak sebelum?
Yes,
last
madam.
case, madam. By Imran, last case.
Last case bagi tahu ni je. Apa consequence dia dan apa kaitan consequence tu dengan case tu saja pendek.
Wafi, can we go to the last slide?
Okay, last slide
Siapa present? Muhammad Imran
Yes, madam. My name is Muhammad Imran. From TLB2. The consequences if the solicitor acted without authority. In this, I will in the case that I will briefly present later. And the court said that the court has an inherent power and authority to refuse or to permit a particular advocate and solicitor from appearing on behalf of an individual. So it says that it's taken from case Emperor against Dadu Ramu, All Indian Report. So the right of an individual to be represented by an advocate and solicitor of his own choice is not absolute. So the court will have the right to decide that. So that is just the consequences if an advocate and solicitor acted without authority, he or she will not be allowed to be represented. That's the consequences. May I go to the case?
Kejap ya. I'm trying to get the point here. However, if there was any tak jelas dia punya slide ni. However, if there was any, the court have an inferent power. If there was any breach of professional etiquette, the court can refuse to permit a particular advocate and solicitor from appearing ataupun the right to be represented Okay, if it is a court that would have been that right. So sama ada the court can actually deter the counsel from acting for the particular client. Also, the
Yeah.
second point, what does that mean? The right of a particular individual to be represented of his own choice is not absolute. Apa maksud di situ?
It means that we know that a person can be represented by his own choice, by his own lawyer, but if there is any breach of contract, breach of professional etiquette, the court will has the power to refuse not to or to ban the advocate and solicitor to represent the individual in the
Okay.
case.
So the court's power is will supersede the right of the client to be represented by the counsel of his own choice. Okay, sebelum daripada itu, boleh tak you all also check in the LPPE ataupun LPA sama ada case lawyers who act without authority can fall under any of the kesalahan tata tertib tu ya, apa tu? Misconduct yang boleh membawa kepada disciplinary proceeding lah. Sama ada boleh dilaporkan kepada bar counsel untuk tindakan diambil bagi kes-kes begini ataupun implicationnya lebih kepada keputusan mahkamah dalam kes ni, hak untuk hak mahkamah untuk menidakkan representation ataupun kes lain tadi untuk mengarahkan counsel membayar ganti rugi yang terpaksa dibayar oleh klien. Ya, banyak consequences dia ni, you boleh explore ya. Dari segi hak mahkamah, hak klien, okay, tindakan disciplinary proceeding, can you explore all these consequences supaya bila you jawab tu jadi komprehensif lah. Let's say lah I were to put up a question dalam final exam nanti. Contoh-contoh consequences ni. Dan jawapan yang bagus adalah jawapan yang explore every angle lah. Okay. Okay, boleh kita tengok apa yang berlaku sepintas lalu sahaja.
Boleh, madam. Okay, in this case, Lau Yan Kui and Ever Mobile Sendirian Berhad, I will say that the Ever Nobel is a developer and Lau Yan Kui is a firm that representing the Persatuan Pembeli Rumah Kuda Lari. Okay, so both party actually had have a consent agreement and have already obtained a consent order. However, Ever Nobel alleged that the firm, the advocate and solicitor of the Persatuan Pembeli, that the plaintiff solicitor had been advising their client to abandon or to ignore the consent order that already been agreed to. There are also another claim, and therefore here comes this case. This case actually a counter application, a counter claim for the said allegation made by the Ever Nobel. However, all the evidence that had been produced or tendered to the court, the judge said there is no sufficient evidence to support first the allegation. There is no evidence to support the allegation, and also there is no sufficient evidence to support the affidavit of the defense to deny all the claims.
So Ever Nobel actually filed a complaint to the Lembaga Tata Tertib Peguam ya?
Indeed, they did file a complaint.
And what happened?
About the complaint.
Yes.
Or the acting with the authority.
What did he proceed to Tata Tertib or not?
No, the court only specific that the issue of acting with the authority should be should be discussed in the case where the advocate and solicitor acted without authority in that particular case, but not in not in current case. For the issue of tata tertib, it is actually had been filed by the Ever Noble, and it is not really deeply discussed in this case.
Okay, this is that I just raised this one just now, that you should also explore to what extent can you refer this kind of issue with regards to acting without or acting beyond the authority to lembaga tata tertib bar counsel. It is interesting to see what kind of cases would fall within tata tertib and which would not. Okay, macam case kalau lihat di sini, case tu is very clear, quite apparent that the counsel has acted against the interest of his own client by trying to persuade the other party to set aside the consent order already achieved by the parties, right? So was he acting in the best interest of his client? And okay, so it's it seemed to be against the interest of the client. Not only that, it was against the authority or beyond the authority granted. Right. So please baca in full case ni dan explore apa yang saya bagi tahu tadi. Alright, ada lagi yang nak present? TLP 1 ada nak present apa-apa tak sebelum saya pergi ke 3 dan 4? Saya dah rasa dah masuk waktu TLP 3 dan 4 dah ni. Ada lagi tak?
Sepatutnya ada satu lagi presentation untuk topik 4, madam. Question 1, topic 4.
Question 1, topic 4. Topic 4 ni topik authority, right?
Yes, and privilege of advocate and solicitor.
Privileges, okay. Okay, tak apa, kita keep that one for the coming tutorial, sebab saya pun memang nak adakan tutorial as much as possible.
Okay, sure.
Kalau boleh saya kekalkan this live meeting. You all boleh leave, boleh tak minta TLB 3 and 4 join this live meeting? Boleh?
Okay, sure madam, boleh.
Saya dah download attendance. Okay, thank you. Nanti kita sambung balik ya. Setakat mana kita stop, nanti you sambung lagi pada tutorial akan datang ya. Alright, thank you. You all can leave. Bagi tahu your friends from TLB 3 and 4 to join this meeting.
Okay, madam.
Okay, madam.
I already informed them. Thank you.
Thank you,
Alright.
madam.
Assalamualaikum.
Thank you, madam.
Thank you, madam.